Namaskar friends, welcome back to Corporate and Securities Law Compass. Today we are discussing one of the most important foundational provisions under the Companies Act 2013, Section 7, Incorporation of Company. This provision is extremely important because it explains how a company is legally formed, what documents are required for incorporation, what declarations must be filed, and what happens if incorporation is obtained through fraud or false information. Every company, whether startup, private company, public company, one-person company, or large corporate group, comes into legal existence through Section 7. This section forms the legal birth mechanism of a company. Now let us understand the basic concept first. A company is an artificial legal person. It does not exist naturally like a human being. It acquires legal existence only after incorporation under the Companies Act. The moment Registrar of Companies issues Certificate of Incorporation, the company becomes a separate legal entity, distinct from its shareholders, directors, and promoters. Section 7 governs this incorporation process. Now let us understand the legal framework in detail. Section 7 provides that a company may be incorporated by filing prescribed documents and information with the Registrar of Companies. Once the Registrar is satisfied that all legal requirements are complied with, the Registrar registers the documents and issues a Certificate of Incorporation. From that date, the company legally comes into existence. Now let us understand the most important documents required under Section 7. The first document is Memorandum of Association, commonly called MOA. The memorandum defines name of company, state of registered office, objects of company, liability of members, share capital, and subscriber details. The memorandum is considered the charter document of the company. Now, the second important document is Articles of Association, commonly called AOA. The articles contain internal management rules relating to board powers, shareholder meetings, voting procedures, transfer of shares, dividend process, and governance mechanisms. The articles regulate internal administration of the company. Now, another important requirement under Section 7, the company must file a declaration from professionals. This declaration is generally given by advocate, chartered accountant, company secretary, cost accountant in practice. The declaration confirms that all requirements of incorporation under the Companies Act and rules have been complied with. This professional certification is extremely important. It creates accountability in the incorporation process. Now, another major requirement. Subscribers and first directors must file affidavits and declarations. These declarations generally confirm that they are not convicted of offenses relating to company management. They are not guilty of fraud or misfeasance. Information furnished is correct and complete. This ensures that fraudulent persons do not misuse the incorporation process. Now let us understand another important requirement the company must disclose. Registered office address, particulars of subscribers, identity proofs, residential proofs, and prescribed personal details. This helps government authorities verify identity and authenticity. Now let us understand a practical example. Suppose three friends decide to start a technology startup. They prepare Memorandum of Association, Articles of Association, Incorporation Forms, Director Declarations, Professional Certification. These documents are filed electronically with ROC through MCA portal. After verification, the registrar issues Certificate of Incorporation. From that moment, the startup becomes a separate legal person. It can own property, enter contracts, open bank accounts, sue others, and be sued independently. This is the legal effect of incorporation under Section 7. Now let us understand why Certificate of Incorporation is extremely important. Certificate of Incorporation acts as conclusive evidence of incorporation. Once issued, the existence of company generally cannot be questioned merely because of procedural irregularities. This principle provides commercial certainty and stability. Now let us discuss another practical example. Suppose after incorporation someone argues, one subscriber signed documents one day late. Can the company's existence automatically become invalid? Generally, no. Because once certificate of incorporation is issued, the company obtains legal recognition. However, fraud cases are treated differently. Now let us discuss the most powerful part of Section 7. Section 7 specifically deals with incorporation obtained through false information, suppression of material facts, forged documents, fraudulent declarations, impersonation, or misrepresentation. This is extremely important from regulatory and criminal law perspective. Now let us understand the legal consequences. If a company is incorporated by furnishing false information or suppressing material facts, then severe action may be taken. The tribunal may regulate management of company, remove company name from register, order winding up, declare liability of members unlimited, or pass other appropriate orders. This shows that incorporation fraud is treated very seriously under company law. Now let us understand a practical fraud example. Suppose promoters use fake identity documents and forged address proofs to incorporate shell companies. Such companies may later be used for money laundering, accommodation entries, tax evasion, or fraudulent transactions. If fraud is discovered, serious penal and criminal consequences may follow under Section 7. Now let us understand another example. Suppose a person intentionally conceals previous fraud convictions while filing incorporation declarations. The incorporation itself may become vulnerable to legal action because material information was suppressed. This demonstrates the importance of truthful disclosure. Now let us understand why professional certification under Section 7 is extremely important. Professionals such as chartered accountants, company secretaries, advocates must exercise due diligence before certifying incorporation documents. False certification may expose professionals to disciplinary action, penalties, professional and professional misconduct proceedings. Therefore, incorporation compliance is not merely clerical work. It's a serious legal responsibility. Now let us discuss another practical issue. Can ROC refuse incorporation? Yes, if documents are incomplete, name is undesirable, declarations are defective, information is inconsistent, or legal requirements are not fulfilled. ROC may seek resubmission clarification or reject the application. This is why incorporation drafting must be done carefully. Now let us understand the importance of registered office disclosure. The registered office acts as official communication address of the company. Notices, government communications, legal summons, and statutory correspondence are sent to registered office. Providing false address can create major legal consequences. Now let us discuss the relationship between incorporation and separate legal entity. The moment incorporation is completed, the company becomes separate from promoters and shareholders. This principle was famously recognized in the case of Salomon versus A. Salomon and Co. Limited. This means shareholders are generally not personally liable for company debts beyond their agreed liability. This principle became foundation of modern corporate law. Now let us understand another practical example. Suppose a company incurs losses after incorporation. Creditors generally cannot directly recover personal assets of shareholders merely because they own shares. The company itself becomes liable. This protection arises because incorporation creates separate legal personality. Now let us discuss another important concept. Section 7 operates together with incorporation rules, SPICE plus forms, digital signature requirements, PAN-TAN integration, and MCA electronic filing framework. Modern incorporation process is now largely digital. This has improved speed, transparency, ease of doing business, and regulatory tracking. Now let us discuss practical lessons for startups and founders. Founders often focus only on business ideas and funding, but improper incorporation can create future problems relating to ownership disputes, invalid shareholding, governance conflicts, regulatory non-compliance, and investor concerns. Therefore, incorporation documents must be drafted carefully from the beginning. Now let us understand another important legal principle. Even after incorporation, if fraud is later discovered, courts and tribunals may lift corporate veil in appropriate cases serious. This means law will not allow incorporation process to become shield for illegal activities. Stern. Now let us quickly revise the key principles. Section 7 governs incorporation of companies under the Companies Act 2013. A company comes into legal existence only after Certificate of Incorporation is issued. Important incorporation documents include Memorandum of Association, Articles of Association, declarations, affidavits, identity documents, and professional certification. False information, suppression of facts, and incorporation fraud can lead to severe legal consequences. The provision establishes transparency, accountability, and legal authenticity in company formation. Now let us conclude. Section 7 is the legal foundation of corporate existence. Every company begins its journey through incorporation under this provision. This section not only creates companies but also ensures that incorporation process remains transparent, lawful, and trustworthy. For company secretaries, chartered accountants, startup founders, directors, investors, compliance officers, and corporate lawyers, understanding Section 7 is absolutely essential because incorporation is not merely registration. It is the legal birth of a separate corporate personality under law. Thank you for watching Corporate and Securities Law Compass. If you found this explanation useful, then like, share, and subscribe for more practical discussions on Companies Act 2013, corporate governance, startup compliance, ROC filings, secretarial practice, SEBI regulations, corporate litigation, and securities law updates.